in any case, we're here today to talk about Title IX and the new regulations that are set to come out any day now. I am going to primarily focus on the proposed regulations, but I'm also going to give a little bit of background on sort of some context and other developments that are happening that impact Title IX. I would request that you all save your questions until the end. Obviously, we lost a little bit of time with some of the technical issues, but you are welcome to put your Q&A in the Q&A section, and hopefully if we have a little bit of time, we'll be able to get through some of those at the end. But if not, I'm more than happy to follow up with everybody, and you're certainly welcome to contact me directly, and I will provide my contact information at the end, and you can reach out to me that way. So let me start with just a very high level overview of where we're at when it comes to Title IX. So as I mentioned, we are waiting for proposed rules, which are scheduled to come out literally any day. They were originally scheduled to come out in May of this year. They were delayed until October, and here we are in October, and it appears that the new regulations are going to be delayed yet again. In the meantime, of course, the current regulations that were adopted under the Trump administration and came into effect back in August of 2020 remain in full force and effect. You may recall that after those rules came in, they were quite controversial, and there were a number of legal challenges. None of those legal challenges were successful in making changes to the rules. So the rules have remained as they were originally adopted, with one minor change, and that is a case called Cardona. And that struck one portion of the 2020 regulations that related to the exclusion of testimony or statements by individuals that either refused or did not subject themselves to cross-examination. With that rule vacated, there is no restriction on using the statements or evidence and which are statements of individuals, even if they don't appear at a hearing or don't subject themselves to cross-examination or don't participate in the hearing. You can still utilize their testimony and their statements. So that's the only change really to the rules that were adopted a few years ago, back in 2020. Of course, shortly after the effective date of the 2020 rules, we had an election and a new administration taking office. And the Biden administration took office in January of 2021. And they essentially immediately began issuing statements, guidance of their intent, regarding their intent to review the Trump era changes and to draft new changes. So we only had new rules for a few months before the new administration took office and began their process and communicated their intent to change the rules yet again. So in addition to their intent and review of the regulations and now the issuance of proposed rules, the Biden administration also had a significant focus on protections for LGBTQ plus students and employees, anyone covered under Title IX. So they have issued numerous pieces of guidance, executive orders, and essentially are focused very much on protecting the rights of students based on sexual orientation and gender identity. So that's one of the biggest shifts that we see, and a priority of the Biden administration when it comes to the Title IX rules, even as they are currently interpreted today, even before we see changes that we're going to discuss in the proposed rules. So the administration began the process of rulemaking. It issued their proposed rules. They issued both a revision of the Title IX rules in total, and they carved out the athletics rule related to transgender athletes, and they issued a revision to that rule separately. So we have these two sets of proposed rules that are pending that, again, will make sweeping changes to the Title IX regulations. In addition to that, of course, over the last few years, we've seen continued and increasing litigation when it comes to Title IX issues. Both complainants and respondents unhappy with the way that their institutions have handled their Title IX issue, have brought those complaints and been fighting those out in court. So there's been a lot of litigation in this area. States continue to pass laws and have passed laws over the last 3 years that may impact and overlap with Title IX. Of course, federal law trumps, but states may adopt rules that address issues that are not covered in the Title IX rules, or add additional requirements and expectations for schools in those states. So as we wait for the final rules, we know that they are controversial. This is unfortunately a controversial area, as are many issues these days. And so we are likely to see even more legal challenges to the new rules once they do come into effect. So a couple of additional developments that I think have really influenced Title IX and this administration's position and stance on Title IX that I wanted to talk about are very high level, two important court cases. One is the Bostock decision, and that is was a Supreme Court case that essentially expanded protections for employees on the basis of sexual orientation and gender identification. And Bostock was a Supreme Court case that focused on Title VII, which is the federal rule that protects against discrimination on the basis of sex in the employment context. But the Department of Education the Bostock case was decided in 2020. When the new administration came into office in 2021, they began issuing different guidance documents and essentially took the position that Bostock's holding, which extends protections to individuals on the basis of their sexual orientation and gender identification, also applies in the context of Title IX. So that's a big expansion or change that we've seen, and again aligns with the focus and priorities of this current administration. Another case that I want to talk about, and this relates to state law and how state law can conflict with federal law. And in this case, there are several states where several state attorney generals from 20 different states essentially joined together to challenge the department's extension of this Bostock decision to Title IX. And these states essentially had passed laws that restrict the use of bathrooms, locker rooms, and participation on athletic teams to an individual's assigned gender at birth. And those states won their lawsuit, and the federal court enjoined the Department of Education from essentially applying this position, extending this protection that was set forth in Bostock to Title IX in those 20 states. So those 20 states, I've listed them here. I know we have participants in schools from all across the United States. And so if you are in one of these states, you may be aware of this litigation and this essentially restriction on the department's extension of rights to transgendered individuals and to students and employees on the basis of their sexual orientation. So it's unclear what is going to happen after the final rules, which I'm going to talk about in a moment, how this issue is going to be resolved, but it is likely that it will continue to be challenged in court and may, we'll probably see litigation in this area. So Title IX, never a dull moment, and definitely a controversial and contentious area. So I know I kind of went through that really quickly, but I hope that gives you a little bit of context into sort of where we are, the current landscape of Title IX. We have a lot of focus again on LGBTQ+ rights, and the issue of transgender athletes are sort of two big areas where we see a lot of activity. And then, of course, the other major change that we see is new pending rules. And I'm going to spend the remainder of my time discussing at a very high level, just sort of highlighting some of the more significant changes that we see in the proposed rules and that we will see likely once those become final. And just a quick note in terms of the timeline for these revised rules. And I mentioned this briefly when I began, but the final rules, and this applies both to the athletic rule and then these other broad changes to the remainder of the rules. Remember, there were two NPRM processes, two proposed rulemaking processes, but they both apply to the Title IX regulations. One just carved out the athletics rule issues and transgender athletes, but we're awaiting final regulations on both of those. And they have been delayed, originally May, then October. Of course, we're into October, almost halfway through the month now, and we still have not seen final rules. And it is very unlikely that we are going to see final rules in October because of the process that the regulations must go through in order to become finalized. The very last stage of adopting new regulations is a final review by OMB. And at the moment, we can see by looking at the Federal Register, and other public information, when the rules have passed into that final last stage before they were released to the public. And we can see, and I just checked this morning, that they have not yet passed into that final stage. Once they do, it could be anywhere from 30 to 90 days before they are then published in final form. So we are looking at this point an absolute minimum of 30 days, which I think is very unlikely, but up to even 90 days before we see final rules. And that assumes that the rules enter into that final stage soon. So in terms of when they become effective, we'll have final rules at some point, but when we have final rules published, that doesn't mean they take effect the day they are finalized. And last time under the Trump administration, I think it was around 100 days or so between the final rules publication and the effective date of those rules. We just don't know what the effective date is going to be for the final rules, but there's sort of a lot of chatter and speculation that it's likely or possible that it would be these rules would be effective the next academic school year in 2024. But again, we don't know until they're finalized. So this is just a very quick overview of some of the areas that are going to see major changes, where we do see significant changes under the proposed rules. And I'm going to talk about each of these areas next. So one of the more significant changes under the proposed rules And this relates back to the priorities of this Biden administration that I mentioned earlier. They have expanded essentially the definition or the scope of what is considered to be sex-based discrimination. So the Title IX statute prohibits discrimination on the basis of sex. And these rules expand what is meant by on the basis of sex to include sex characteristics, sex stereotypes, pregnancy and related conditions, sexual orientation, or gender ID. The department has really already adopted through its guidance documents and its position, as I mentioned, that Title IX applies to sexual orientation and gender ID. And these final rules would really codify that in the law. So it remains to be seen what will happen in those 20 or so states where the department has been enjoined from enforcing this position with respect to gender ID and sexual orientation. But when the rule becomes final, it will be codified in law. Another, and let me just say that just as a general rule, big picture, the changes under the proposed rules essentially do two things. First, they greatly expand the scope, coverage, and jurisdiction of Title IX. Right, as I just mentioned, they have essentially redefined what on the basis of sex means to include many other categories. So that's one expansion. And in addition, they have made clear that the Title IX rules apply to all types of sex discrimination, not just sexual harassment. The 2020 rules were very focused on establishing very specific criteria, requirements, and expectations around how schools must respond to sexual harassment. The changes to the regulations make clear that all of the requirements, including grievance process requirements, all of the requirements within Title IX apply to all forms of discrimination, not just sexual harassment or sex-based harassment as these rules adopt some new terminology, but sexual harassment, sex-based harassment, the same thing. The other thing that these rules do at a very big high level, in addition to greatly expanding the scope of the rule, is they allow much greater flexibility, a lot more discretion on the part of the schools, to adopt policies and procedures and practices that are an appropriate fit to their particular campus population, programs, et cetera. So we are going to see a broad expansion of the rule. At the same time, schools are going to be given a lot more flexibility and discretion to craft approaches that they think best meet their mission and their particular circumstances. So getting back to this question of applicability of the rule, Title IX applies, of course, to institutions, educational institutions that receive federal financial assistance of some sort. And Title IX prohibits discrimination in those institutions when it occurs within the scope of the institution's educational program or activity. And typically the educational program or activity is going to obviously include the school's campus, your on-campus activities, conduct or discrimination that occurs within a school-sponsored off-campus event. So it's not simply limited to on-campus, it's within the scope of that program or activity, wherever that program or activity may be occurring. And it also includes misconduct that occurs in buildings that are owned or controlled by student organizations. The proposed rules, again, very significantly expand the types of conduct that are covered under Title IX. And they expand essentially what is meant by educational program or activity, or when there is a triggering of a school's obligation within the program or activity. So one change is that the geographical limits are removed under these current rules, or I shouldn't say current rules, excuse me, under the proposed or pending rules. The current rules exclude conduct that occurs outside of the United States. So conduct that occurs in a study abroad program or something of that nature is excluded. Under the current rules, sorry, I keep saying under the current rules because they're so close to being released and becoming current. Under the proposed rules or the pending rules, discrimination or misconduct that occurs outside of the United States may be included and may trigger a school's obligation to act and address the situation if it contributes to a hostile environment in the school's education program or activity. And that expansion would include really to any location. So the emphasis is going away from where the misconduct occurred and is shifting to where are the effects or impacts of that conduct experienced. And so if there is off-campus conduct that occurs completely outside of a school's educational program or activity, it could be at a private home, it could be at a off-campus bar or restaurant, anywhere. If the individuals or the parties that were involved return to campus and there is a hostile environment that is created, or the complainant's access to the school's educational program or activity, or the benefits and participation of the school's educational program or activity are denied or limited in any way, then you Title IX may apply in those situations. So that is a huge expansion of the types of conduct and situations that under the proposed rules as written would cover. In addition to that, the proposed rules extend jurisdiction for Title IX in situations that may be outside of the school's program or activity, but where the school exercises some sort of disciplinary authority. So if the school has a code of conduct that prohibits assault between students, or any conduct, any type of misconduct, irrespective of where it occurs, and the school exercises disciplinary authority in that context, then a Title IX sexual harassment or other misconduct or discrimination that occurs in a similar context would also then be covered under Title IX. So again, the focus is on more of the impact of the misconduct, and if that impact affects their ability, again, to fully participate in the school's program or activity, or creates a hostile environment back on campus, then Title IX may apply. And we're going to talk about sort of what the analysis under the rule looks like to determine whether or not the school would exercise or have jurisdiction and be required to take action. So we've talked about the broadened scope of what is meant by on the basis of sex, or what is sex discrimination under the rule. We've talked about the increase in scope in jurisdiction and the locations or contexts in which the rule may take effect. Another significant change that expands the applicability of the rule is a new definition of sex-based harassment. Under the current rule, it's sexual harassment, a slight change in the verbiage. Under the current rule, the pending proposed rule, it is now called sex-based harassment. Under both regimes, under both current rules and the proposed rules, sexual harassment is comprised of 3 prongs. And those include quid pro quo. That's when an employee conditions something of value on in return for some sort of sexual favor, or the VAWA, Cleary VAWA crimes of sexual assault, intimate partner violence, and stalking. So those 2 prongs essentially remain unchanged. Where the change comes in is to this 3rd prong of sexual harassment, which is also sometimes referred to as hostile environment harassment. Now, under the current rules, what is considered sex-based harassment was significantly narrowed, and it was defined in a manner consistent with Supreme Court definition in the Davis case specifically for sexual harassment. The proposed rule, again, expands the definition of sex-based harassment to include unwelcome sex-based conduct that is severe or pervasive, objectively and subjectively offensive, which has the effect of denying or limiting the complainant's access to the school's educational program or activity or other benefits. So the big change here is that under the current rules, it was severe and pervasive and objectively offensive. Under proposed rules, it's severe or pervasive and objectively or subjectively offensive. So a significant change here, and the proposed rules set forth a totality of the circumstances test to determine whether or not sexual harassment exists. I'm actually going to skip over this. There's a 5 sort of factor test that the regulations set forth. But I do want to move on to the notice and reporting requirements, because again, here we see an expansion of expectations for schools with respect to Title IX. The biggest change is that the rule essentially eliminates the actual knowledge requirement. So there is no actual knowledge requirement. Instead, there are multiple employees that now have an obligation to report Title IX concerns that they have knowledge of to the Title IX coordinator, or to provide the Title IX coordinator's contact information to the reporting party. The rules, the proposed rules, are a little bit convoluted in terms of who has to report what, when, what classification of employee. So I'm not going to get into the details with that. What's important to remember is that for K through 12 schools, and this isn't a change, all employees are mandated reporters. But for higher education institutions, all employees are going to have a requirement either to provide Title IX coordinator contact information to the individual that is reporting to them, or to provide the Title IX coordinator with information about the report that they've received. And there continues to be an exception to this for employees that the school has designated as confidential employees. So no actual knowledge requirement, and additional requirements for all employees to be put on notice and to take appropriate action regarding bringing that to the Title IX coordinator's attention or providing contact information. An additional change is that, and this is a completely new requirement under the proposed rules, is that the Title IX coordinator has another job responsibility added to their seemingly never-ending list of requirements and responsibilities. And that is that Title IX coordinators have an obligation under the proposed rules to have some sort of monitoring process in place to monitor whether there are any barriers for individuals to reporting concerns around Title IX violations. And the coordinator must take reasonable steps to address potential barriers that exist. Obviously, the intent here is to encourage reporting of discrimination concerns. In the interest of time, I'm going to just very briefly highlight a couple of changes with respect to supportive measures and emergency removals. First, the supportive measures, provisions, and requirements remain largely unchanged. You must still provide supportive measures to both parties, and that is an important requirement in all cases, in all reports of Title IX, irrespective of whether or not the complainant wants to move forward with an investigation or a complaint. What is a little bit different under the proposed rules is that there is a greater availability or ability for schools to impose supportive measures that may be burdensome to the respondent. There are a number of sort of protections that are built in, but schools may implement supportive measures that are burdensome to the to the respondent. And they have a broader allowance to implement an emergency removal of a respondent. Specifically under the current rules, emergency removals are justified. Again, there has to be an individualized threat assessment under both current and proposed rules. But under the proposed rules, an emergency removal may be warranted and justified even if there isn't a physical threat of harm. So that's a pretty significant change with respect to emergency removals under the proposed rules. Okay, so another very big change, and possibly a welcome change to many schools, are the changes that we see with respect to the grievance procedures. The proposed rules set forth two approaches, two sets of grievance procedures. There are some overarching requirements that all schools in all cases must follow, and those are set forth in section 106.45. These are not specific, they are not proscriptive, they set forth, again, some very sort of generic requirements that schools must follow. Otherwise, schools, again, have the flexibility and discretion to adopt grievance procedures that meet their specific needs. And when you're looking at these overarching requirements and the overarching broad grievance process that you have to adopt, it's important to remember to consider state law and any judicial and decisions that may impact your state or your campus. So even though the prescriptive requirements have been largely removed from the federal Title IX grievance process, it's important to look at other law and make sure that you're complying with that. So those overarching requirements apply to all cases. For cases that involve sexual harassment at the post-secondary level, in cases that involve at least one student, there is another set of grievance requirements that apply, and those are set forth in section 106.46. And those, I'm gonna, my slides move here. There we go. We'll talk about 106.46 in a moment. I'll just briefly touch on a couple of highlights of these general grievance procedures. Again, they're going to apply to all complaints, including those that fall under 106.46. So sexual harassment at a higher education institutions involving students, these will apply in addition to the more prescriptive requirements that we're going to get to in just a minute. But in general, the biggest changes here, and there are a lot of big changes. First of all, there's no requirement for a formal complaint. Any individual standing and any complainant that is expressing a concern and wants the institution to implement its grievance procedure or conduct an investigation, the school has an obligation to move forward under their grievance process under 10645. So those complaints can be verbal. They do not have to be in writing. There is no formal complaint process that is required. So it takes a lot of that formality out of the requirement. So you can see that it's likely that you're going to have a big increase in the number of cases with that formal complaint requirement removed under the proposed rules. The other two very significant changes here is there's no live hearing requirement and there's no requirement at all for cross-examination. Okay, just checking on the time. The basic overarching requirements, I'm not going to go into those. They're sort of, general fairness sort of considerations. And I'm not going to go over what's not in the grievance procedures. What I will say is, again, there are these very overarching requirements. You're not prescriptive until you get to cases involving sexual harassment at post-secondary institution and cases involving a student. Then there are some additional, more prescriptive due process protections that are very similar to the current requirements. A big difference here is that, similar to 10645, the requirement for a live hearing and cross-examination continues to be optional, even under these more prescriptive requirements that are going to apply at the higher ed level. The only requirement is that, I shouldn't say the only requirement, but with respect to cross-examination and the live hearing, the intent of those requirements is that there has to be a method for the decision maker to test credibility of the parties. And so there has to be some process, and that can be in individual meetings, that could be in a live hearing, but it doesn't have to. Schools have a lot of flexibility in terms of how they want to effectuate that requirement. And again, it's very important that you look at your state law, because many states have laws, and then certain federal districts have adopted expectations with respect to what constitutes due process. So that'll be important for you to make sure that you understand in working with your legal counsel. I know we're getting short on time here. Michelle just sent me a message and said, feel free to go past our end time. If I do happen to go past the end time, obviously, if I'm not able to get to a question that you may have asked, or you have some follow-up questions for me, you are more than welcome to contact me via my email, which is going to be included in the presentation, which will be posted on ACCSE site. And you're also, I'm happy to provide a copy to you. I'm also happy to provide a PDF copy if you wanted to post it for disclosure purposes on your website. You can either go to my website at T9 Now or shoot me an email, and we'll make sure to make that happen. So I just wanted to mention that just in case we go over, because it is looking like we're getting very close to time here. So getting back to the presentation and some of the more significant changes under the proposed rules. Current rules do include protections for pregnant and parenting students and employees. The proposed rules expand on those requirements and add a lot more specificity around those expectations. So some of the more significant changes relate to the notice requirement. So if any employee becomes aware of a pregnant parenting student, they must provide the Title IX coordinator's contact information, and then the Title IX coordinator has to reach out to that individual and provide them with a notice of their rights. That includes all the items I have listed here. I do want to note that schools must have lactation space for all students and employees, and that lactation, and it must provide for reasonable breaks. And that lactation space must be clean, free from intrusion, and it cannot be a bathroom. I just want to make one quick point about informal resolution in the interest of time. Informal resolution is allowed under the proposed rules as it is allowed under the current rules. The proposed rules give us a little more specificity in terms of the requirements around informal resolution to ensure that parties can make, voluntary informed consent about whether that or not they want to participate. But the two things that I want to mention is that a big change is that because there is no formal complaint requirement, and under the current rules, students could not consider or engage in a formal resolution unless complainant filed a formal complaint. That requirement is eliminated under the proposed rules, which I think will make informal resolution perhaps a more attractive, potentially, option for the parties. And with the great increase in the number and types of cases that you're going to see under this expanded proposed rules, if you don't already have informal resolution options in place at your campus, this might be something for you to take a look at. A quick note about the transgendered athletes issue. As mentioned, the department did issue a separate NPRM, which will likely be grouped together when we see those final rules covering all of the issues that I've talked about today, all of the changes to Title IX. But in a nutshell, what the rule does is it essentially prohibits a categorical ban. Schools may not have categorical bans across the board bans that prohibit or limit participation on an athletic team based on an individual's sex assigned at birth. The proposed rules set forth, as you can see here, sort of the requirements that must be considered and that would be applicable if a school does include a limitation. So schools may limit as long as that limitation is substantially related to the achievement of an important educational objective, and that limitation minimizes the harms to transgendered athletes. There's a lot of open questions here, and it is very likely that we're going to see litigation on this issue, continued litigation, once the rule takes effect, assuming that this remains in place as written. We're almost done here. There are greatly expanded training requirements under the new rules. Current rules limit required or mandatory training to your Title IX team. Proposed rules, all employees must be changed. So obviously there's a big change there. And then there's specific training required for specific types of employees, depending on what their roles and responsibilities are. I'm going to skip over this, and wow, 12:01, here we are at the end. I rushed through a little bit there. So I already talked about the fact that the new rules are delayed, and we really don't know when they're going to be released, but we know that there is that 30 to 90 day time period once they pass through that final review stage before they become final. And then the effective date, we'll just have to wait and see. I've already mentioned this a couple times, but it's really important to make sure that you are considering any overlapping laws. With the broadened rule, there are going to be many more cases that are coming to the Title IX office. There are expanded training requirements, as I just mentioned, additional requirements and expectations, and a focus around the rights of pregnant and parenting students. And as I already mentioned, something to think about would be considering adopting informal resolution options to help resolve issues when parties consent and voluntarily want to participate in that process if you don't already have those in place. So apologies for the technical issues that we had in the beginning. I'd like to, if individuals want to stay on a little bit later, I'm happy to take some questions. And let's see here.
So, Christine, I think that Karen sent you over some of the questions from the Q&A.
All right. Okay, someone asked about pregnancy and related conditions, and what does this mean? What are related conditions? Any condition that arises out of an individual's potential pregnancy, termination of pregnancy, childbirth. This could be ending a pregnancy. This could be obviously childbirth or potential complications that arise out of a pregnancy. So with respect to pregnancy and related conditions, it's very broad. There's a lot of ambiguity around protections based on parental status. But essentially, pregnancy and any condition that is related in any way to pregnancy is protected and is essentially to be treated like any other temporary disability. Let's see, do K through 12 students and employees, are they covered if they don't receive federal funds? No, they are not covered if they don't receive federal funds. However, the meaning of federal financial assistance is much greater than Title IV. So federal financial assistance is literally any type of federal funding that your school may receive or that your students may receive. So for example, some of the COVID related federal funding benefits, that's a form of federal financial aid. It's very expansively interpreted, and my understanding is that there are very, very, very few schools that don't fall under Title IX because they receive some sort of federal financial aid. How do we handle a verbal grievance? A verbal grievance would be handled. So one of the things that I didn't touch on, and just again, in the interest of time, this was a very high level highlight of some of the more significant changes. A lot of the requirements under the current rules in the formal grievance process, there are a lot of protections that are built into the process. And almost at every stage of the process, there are written notices, the sharing of written information, sharing of evidence, sharing of the investigative report, et cetera. Under the overarching requirements of the proposed grievance procedure, again, the procedure that doesn't include higher education, sexual harassment, including students, almost all of those mandatory written requirements are eliminated. That said, there are still record-keeping requirements under these rules, and those are very similar to the record-keeping requirements under the proposed rules. You must retain documentation related to complaints and your response. So while you may receive a verbal concern or complaint, and you may not even have to provide anything in writing, you're probably going to want to document that. So you'll definitely want to document the various responses that you take. It's just that the timing of that documentation isn't as prescriptive as it is under the current rules. And then in terms of how you actually handle the grievance, accepting complaints that fall under 106.46, it's going to be up to you as an institution to draft a grievance process that meets your school's mission, your school's population, your needs, as long as it meets those very overarching requirements. So you have a lot of discretion and a lot of flexibility in crafting grievance procedures and determining how you're going to respond to verbal complaints. I hope that answered the question. Geographical limits removed includes Puerto Rico. Well, Puerto Rico is a U.S. territory. So my understanding is that it would be included under Title IX. Okay, so I think those are the questions that I see in the Q&A. Any other questions from anyone? A PDF, yes. So as mentioned, the video is going to be posted on ACCSC's site. I will also provide a copy of the PowerPoint, and I will make that available in a PDF version so that you can post it on your website to comply with the Title IX disclosure requirements if you'd like. Please email me directly if you'd like me to do that, and/or I'll be in communication with ACCSC around how we can get that to you.
Well, Christine, thank you so much. You know, I think for those folks that are on the webinar, you can, I think, clearly see that Title IX is at least as complicated as setting a webinar up. So just a ton of information here. Christine doesn't need to apologize for the technical difficulties. It was totally on our end. So we'll continue to practice. Just purely couple of people here, myself included, just not having a lot of experience with setting those up. But we'll make the next one a little bit better. So sorry about the hiccup. But that notwithstanding, the rest of the email or the rest of the webinar went great. I mean, just a ton of information, really useful. And I think for me, the overarching point here is there's a lot that you need to know and a lot that you possibly can't even imagine that you don't know. And so having some expertise like Christine's and the services that she provides, you know, may be a useful resource for institutions. And so, you know, there's just so much change that is continuing to brew. You can pretty much expect that going forward. So I would encourage you to, if you find yourself in a position to have some questions around Title IX, you know, are we getting it right? Are we not? Do we have work to do here? To reach out to someone with the kind of expertise, experience, and knowledge that Christine has. So Christine, thank you again. Fantastic job. Again, ton of information. Pointed out the webinar will be available on the website. So we have that. And if anybody has anything else, as she said, she's provided her information for you. Feel free to reach out to her. If anybody has questions about this, you know, in relation to ACCSC and standards, feel free to reach out to myself or anybody else here on the staff, and we'll do our best to try and get you some information. But this is not our bailiwick. This is you know, something that we rub up against tangentially at best and peripherally. So you know, finding somebody that really has a high level of expertise in this regard is really useful. So with that, again, thank you for your time and for your attention.
Thank you so much, Michael, and thank you everyone for participating. Again, apologies for the technical glitch. I know it was like drinking from a fire hose. It was a lot, and it was on like fast forward speed. If you go to my website, just one other thing to mention is you can sign up for my newsletter, and I provide updates on development. So when the new rules do come out, I'll make sure to be distributing that and other information about the new rules once they become available. So thank you again. I hope everyone has a great afternoon. Take care.
Thank you so much. Take care. Bye-bye.
Bye-bye.